What I would say, the Investment Advisors Act provides the fundamental fiduciary protections that investors need when they're in a relationship of trust relying on someone for investment advice. It gets the standard right. We're at a stage now, this is actually a really interesting time to be looking at the Act, because what we've seen is over the last 30 years, the basic protections that the Act should afford have been seriously eroded. So some have tried to suggest that the problem is that the Act hasn't kept pace with changes in the marketplace. The Act was actually written perfectly to address changes in the marketplace. It applies a principles-based definition of investment advice and provides a very narrow exclusion for broker-dealers. Unfortunately, the SEC has chosen in implementing the Act over the last 30 years to apply it in a way that allowed broker-dealers to essentially rebrand themselves as advisors and escape the appropriate regulation for that role. Had they applied the law as written, we wouldn't be here today. We wouldn't be at this point where we are today, where we're saying, what are we going to do now to ensure that when broker-dealers act as advisors, they're subject to the appropriate standard? And so it's a moment of both great promise and great peril, because the potential is there, if the SEC were to take appropriate action, that we could finally see the protections afforded by the Act applied as they should to the advisory activities of broker-dealers. And that would be a huge step forward for investors. But the peril is that the SEC will, in adopting rules to achieve that end, or at least purportedly to achieve that end, will so water down the standard that applies under the Advisors Act fiduciary duty in order to accommodate the broker-dealer business model that we're left with pretty much business as usual for brokers, no meaningful changes in the way they do business, and a watered-down standard for advisors from what we've come to expect. Consumers absolutely cannot and do not distinguish between financial advisors, who are salespeople, and investment advisors, who are advisors. Why would they? There's no and disclosure doesn't solve it, and education doesn't solve it. If you tell them the differences, they still don't know whether their own advisor is a broker or an advisor. So that's why we focus so much on ensuring that they don't have to know, so that when they walk in and they enter that relationship, they don't have to know, because the standard would be the same standard. If you're giving advice, you're required to act in the customer's best interest. You're required to mitigate conflicts of interest. You're just required to disclose material information. It is unreasonable to expect that people who lack basic financial literacy skills are going to be able to assess the quality of advice that they get. So they need the assurance that the advice that they get is in their best interest. That a professional who is knowledgeable has looked at their situation and sought to determine what is the best course of action for them and how best to implement that. The reason I always come back, like a broken record, to the fiduciary standard is that investors, however much we improve those other things, investors are still going to need to know that the person across the table from them who's giving them advice is giving them advice, and not just a sales pitch dressed up as advice. And that is the overwhelming expectation that investors have, regardless of whether they talk to a financial advisor or an investment advisor.